Hello and welcome to our special broadcast. I'm Parikshit Luthra. In a major setback for Patanjali, the Supreme Court has refused to accept apology from Baba Ramdev and Acharya Balkrishna once again. While hearing a plea by the Indian Medical Association, the court gave Ramdev and Balkrishna a tongue lashing for willfully violating court's orders and issuing misleading advertisements, falsely claiming that their product Coronil can cure COVID-19. Remember, Patanjali Ayurved launched Coronil in early 2021, where COVID cases were on the rise in India. Two ministers of the Narendra Modi government, former Health Minister Harshvardhan and Transport Minister Nitin Gadkari, attended the launch event. Ramdev claimed the tablet was the first evidence-based research cure to COVID-19. Later, when the Indian Medical Association questioned the veracity of the claims, the government's Ayush Ministry clarified that the tablet has only been approved as an immunity booster. However, that did not stop the Haryana government announcing that they will distribute 1 lakh Coronil kits among COVID patients. Today, the court also pulled up the Uttarakhand regulators for inaction against the company. The court went to the extent of saying that it is inclined to issue a contempt notice to state regulators, but is refraining to do so at this stage. The apex court has now posted the matter to the 16th of April. Joining us now to take this ahead, I'm joined by Murali Neelakantan, Principal Lawyer at Amicus, and Dr. Jayesh Lele, former Vice President of the Indian Medical Association. Gentlemen, thank you very much for joining us. Dr. Jayesh Lele, let me begin by asking you, the court coming down very heavily on Patanjali Ayurved for these misleading advertisements. What is the larger impact that all these misleading advertisements would have had, and why do you think it's important for the court to set a strong example in this case, considering that this company, even after a rap from the Supreme Court, had advertised the powers of other medicines for issues such as diabetes, blood pressure, arthritis?
Yeah, thank you very much. Let me make it very clear that this is not only against the Coronil, but as you mentioned at the later part about all the medicines and claiming them. And here I must say that when the Coronil was launched, that time I filed a RTI in the Ayush Ministry and the Mantralaya and the Health Ministry in Delhi. And I got an answer that this is not meant for that purpose, number one. In spite of our registering FIRs in Patna, in Madhya Pradesh and various police cases, complaints, no action was initiated, and it went on to not only say about the Coronil, but they went on to humiliate allopathic doctors, allopathic medicines, and claiming false claim that allopathy is wrong and Ayurvedic is the best. Here, let me make it very clear that we are no way against any pathy. We are equally, all the pathies, the patient has a choice of taking whatever medicines he wants. But today, when we are in the evidence-based medicine, we have our ancient charak and we respect them. But at the same time, in the Coronil time, that time, so many patients were dying. People were searching for various methods and best methods to be used. And this person was saying that because of the allopathic giving oxygen, people died. Such a humiliating statement, and and all those videos were causing really nonsense and the flutter among the allopathic doctors. And second, another advertisement which you mentioned really just now about various medicines. And that time I was the person who prepared the case, and our advocates, senior counsels filed this case in June 22, and then this is the 2 years outcome of fighting. And today we really welcome the strong action initiated and taken and noted by the Honorable Supreme Court. We are very thankful to the Supreme Court.
All right, Mr. Neelakantan, let me get you in at this stage. Where is the gap in the law? Why is it that different state governments, now be it Coronil or other medicines being sold, being retailed by Patanjali Ayurved, this was happening across states. Any state government could have acted against the company for these misleading advertisements. Why do you think no one really acted?
I don't want to comment on people's motives. All I can say is the law is very clear. There is no gap in the law. If you look at the Magic Remedies Act, if you look at the Drugs and Cosmetic Act, it is very clear. Under the Drugs Act, there is a schedule of 58 books, which we acknowledge are books that have source of knowledge in Ayurveda. None of these medicines can find a basis in those books. There is also a requirement under the rules, Rule 158B, to prove effectiveness. We know that none of these drugs has proved any effectiveness. Then we come to the issue of advertisement. We could have very easily solved this problem if the government was not supporting all of these people who were selling the snake oil. They would not be able to sell it. We had government supporting these drugs. We had government selling these drugs, giving them free. So all this happened because of government support. It could not have happened without government support. And today the Supreme Court acknowledged that and asked the government, what have you been doing for 3 years? Let me just say that the advertisements that are prohibited are in respect of fever, heart disease, blood pressure, obesity, everything that Patanjali and many others like Patanjali. So let's just not pick on Patanjali. Many others like Patanjali have been selling for a very long time. If only the newspaper and these people who are producing it are prosecuted and sent to jail for 1 year, which is what Magic Remedies Act provides. How many you think will risk it? How many newspapers will carry it? How many TV channels will carry these ads? If the owner of the TV channel and the editor of the TV channel and the newspaper is sent to jail for 1 year. That has to be the test. When media is willing to participate in this, government is willing to support it, obviously you will find these players willing to play the game. And that's what Patanjali has done.
Right. Mr. Neelakantan, I'll also like to ask you, the Supreme Court today declined to accept the apology of Baba Ramdev and Balkrishna and Patanjali Ayurved, saying that you already went to the public before coming to the Supreme Court and this will not be accepted. But what are the options at this stage under the Magic Remedies Act, under India's healthcare laws? What are the options before the Supreme Court? What is the kind of action, or what are the kind of actions for misleading advertisements, propagating such medicines? What kind of penalties could they be in for?
Sorry, we'll have to understand that the Supreme Court is not enforcing the law. It is the executive that needs to enforce the law, which is what it is asking the state government to do. Why are you not prosecuting? Why have you just been pushing paper? So let's get it very clear. The case of contempt relates to a very small aspect of their behavior. In a previous hearing, Patanjali, Baba Ramdev and lots of people were told, don't go outside and say anything. They violated that by having a press conference that very same evening, where a whole lot of claims, including aspersions cast on the Supreme Court, were made in that press conference. This contempt hearing relates to that behavior of Baba Ramdev and others. It doesn't relate to the enforcement of these two legislations. What is mentioned today just across in court, but not in an order, is asking the state government of Uttarakhand why they have done nothing despite complaints received from the IMA, Dr. Lele, from Dr. Babu and many others for many years saying this is against the law, please stop manufacture and sale of these drugs. So there are two separate proceedings happening. The contempt is in relation to the press conference that was had where they said, we will pay 1,000 crores in fine, dissimilar to burners at the stake if we are wrong kind of stuff. That is what the contempt story is about. The underlying proceedings, as Dr. Lele mentioned, relate to these advertisements, relate to, in a sense, maligning modern medicine. So there are two separate proceedings. The Supreme Court cannot now say, go to jail under the Magic Remedies Act. That the Supreme Court can't do. That has to be a trial for it. It will go back to the court.
Okay. We have to see what kind of directions they issue when they're issuing final orders. But let me get in Mr. Lele once again. Jayant, Lele, we have at least 250 crore worth of coronal kits that have been sold. Give us a sense of what kind of action now that you're expecting from the state governments. Is there some sort of immediate relief that you're asking? Any kind of intervention that you want the courts to make?
Yeah, first of all, let me make it very clear that we will have to go back and see what was the situation that time, and those coronal drops and coronal tablets when it was publicized, and in spite of our objections, people bought it. And to my surprise and to everyone's surprise, at the rural village where they see the TV and the media more than they read the newspaper. See, they don't know that IMA has opposed that, and unfortunately, in the rural poor health folk of our Indian side, they took the medicine, and so many went to the hospital in a delayed mode and they expired. See, during the second wave and to third wave, that was the portion where we had a maximum death. In fact, that time, not only the patients died, but doctors also died during that time, because the many serious patients reported to the hospital very late, because that time even the controversy of regarding the oxygen, regarding the vaccine, regarding the treatment was maligning allopathic medicine was there. So ultimately the effect is now we will have to study not only that, those kits what you are talking about, that why what was the how many patients consumed that, and I don't know, it will be very difficult to that. At least the court, we expect from them that the nowadays whatever the medicines he has claimed on that should stop certain sale of those products what he has put it, and to investigate everything properly from the independent authority, from the various scientific researches, and really say that, because today advertisement is there, we have seen n number of patients stopping the diabetes medicine, stopping the blood pressure medicine, and landing into the renal failures, landing into the diabetic issues, landing into complications with the heart. So we have another major disease. Corona is over now, but those diseases which we call it a kind of NCD, that is a non-cognitive, these medicines, the diseases for which our world, which is the developing countries, are facing it. So we need to be very, very clear on that method, whether to stop those medicine, investigate medicine, and then only they should be allowed to sell those medicines now.
Right. Mr. Neelakantan, do you feel that, considering there are questions that have been raised by the court for the government as well, considering the big following that Baba Ramdev has across the country, do you think it's somehow important for the government to maybe put out an awareness campaign telling people about such medicines, about the efficacy, and maybe bring out things transparently and avoid such cases in the future as well?
I think a very easy order by the Supreme Court could have been to say, publish, just like you've been publishing full-page ads about your medicines, please publish from today for the next whole month in every publication you have published until now, a full-page ad apologizing and confirming that these medicines do not work, they have no scientific basis. Please put out an apology and please put out this clarification with as much rigor and as much enthusiasm as you put out your ads before. Withdraw all the drugs that are in the market today until we are satisfied that they work. 2-paragraph order would have been fantastic. We have not seen an order. So as a lawyer, I worry that all this interaction in court may not result in an order. And I'm a little cynical. So until we see an order with these two elements in it, it just seems like, the Supreme Court expressing how it feels. But I'd like to see this in an order, see these two aspects in an order.
Right. Mr. Lele, when Coronil was launched way back in 2020, the IMA, the Medical Association, had said that there's a smear campaign against COVID-19 vaccination drive. Some of these drugs, these Ayurvedic medicines which were being propagated as evidence-based cure, how do you think it interfered with the traditional treatments of doctors across the country? Allopathic and antibiotic treatments.
Yeah,
and why do you think it's important to set an example now?
Yeah, definitely. See, the corona came into the world and India to that extent somewhere in the month of Feb 2020. And the vaccine in India came in the month of Jan 21 or Feb 21. And to stop this vaccination and to sell the Coronil tablet, the advertisement and the introduction came into the somewhere around April 21, April or May 21. So what if you follow the flow of the event, if you see the second wave and the third wave had a maximum death among the doctors and the patients. And that was the effect when the coronil was being introduced. And at the same time, the vaccine, see, people thought that, see, now naturally, in the first time, whenever the first vaccine comes up, there need to be have the study and the vaccine was studied properly. Whereas this coronil, when they claim, and when they claim that the WHO is certified, to my great extent and the knowledge, in fact, every day we used to receive the bulletins and we used to receive the WHO statements across India, across world. Never it was mentioned that the coronil is marketed, and it was, kind of said that WHO has certified, and ultimately the government and the Ayush Mantralaya had to withdraw their own statement. So that itself shows that this marketing was wrong. Marketing was totally biased on to selling the coronil, and we need to be very, very clear. Such orders, and not only coronil, but any medicine which is wrongly said that evidence-based, there has to be an independent authority, independent claims to be made. So this false claim, this needs to be properly punished and properly stated by the Honorable Supreme Court. So we really appreciate now with that. And the second thing I must mention here is that if the government can study the death of those particular 6 months patient dying of corona, then we'll come to know the more incidences and more clarity on this method.
Right. Let me get in one final word from Mr. Neelakantan. When it comes to current laws, it has been said that current laws have enough teeth to deal with such misleading advertisements, to deal with such cases. What are the options, legal options, that are already there with different state health regulators for acting against medical companies for such claims? Mr. Neelakantan.
It's a very simple process. The Magic Remedies Act is a very short piece of legislation. It's only 2 pages. It has a list of indications that you cannot advertise about, which includes fever, and as Dr. Lele said, cardiac health, blood pressure, fevers, heart disease, obesity. So it has a whole list, a list of about 20 items, where it says you cannot advertise in relation to these drugs. Secondly, it punishes those who are advertising, which is the advertiser itself, and also the media. And so if you put one media owner and one of these advertisers in jail for a year, which is the maximum punishment under the Act, and fine them the price of those medicines, I think the next morning, no media company will agree to carry these ads ever. And that way you will end this exercise of there being any advertisement. If no media company carries this, no channel carries these ads, then the people are actually protected. That is the easy way out. And it is very easy for a state government to do this. It can launch a prosecution by itself. It's very easy to get a conviction under this because there is really no defense. I show the magistrate the ad, and I show the company, and there is the conviction. It will hardly last 2 weeks. There is nothing to be tried in this case. There's no trial to be done. It's an easy conviction. Sadly, no state government is willing to do it. And so it must say something about the great influence that this company and companies like this have with governments, both center and state. That's the sad part.
Right. We've run out of time, but thank you very much, Mr. Neelakantan and Mr. Lele, for joining us on the program, telling us about the importance of the observations of the Supreme Court with regard to the Patanjali case and what we're expecting in the days to come. Hopefully, this is a wake-up call for medicine companies and drug regulators across the country as well. We're taking a break here on the program, but coming up, green energy company Renew claims to have achieved the 10 gigawatt milestone in renewable energy assets. We speak to the company's founder and CEO, Sumant Sinha, on the other side. Stay tuned.